The United States Supreme Court has handed down a massive 9-0 unanimous ruling that fundamentally changes when law enforcement can march right through your front door without a warrant. So if you think that your home is completely protected, you need to watch out because the Supreme Court delivered a massive warning for property owners nationwide. In a critical lawsuit, the Supreme Court was forced to confront a dangerous loophole regarding how lower courts evaluate emergency entries into your home. The state courts tried to create a loose framework that could have completely vaporized your privacy protections within your home. The Supreme Court stepped in and issued a massive correction, but inside that unanimous ruling is also a hidden trap that everyday Americans need to be aware of. So we need to break down what exactly the Supreme Court did in this ruling, what happened in this case, and what this means for everyone nationwide going forward. Now, before we jump into what the Supreme Court did in this ruling, if you like this type of content and you want to make sure that you get it going forward, make sure you subscribe to the channel and also turn on all notifications so you never miss these videos when I release them. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member and add in new benefits that other companies cannot offer. So if you're interested, if you want to check them out, you can do so using the links down below. And also right now, if you decide to sign up and you use my exclusive code ARMSCHOLAR, for a limited time, you can get $50 off of your individual sign-up fee or $25 off of the family sign-up fee. Now, to understand the impact of what just happened, we have to look at the unsettling facts that triggered this battle in the very first place and how this eventually made its way to the Supreme Court. So this really all started when police received a report regarding allegations and threatening statements made by Mr. Trevor Case. Now, the call was made to 911 by Trevor's ex-girlfriend, and when talking to the police, she admitted that she couldn't actually remember exactly what he said to her on the phone, but she told the officers that she had a bad feeling and warned them that maybe he was dangerous and would try to harm them if they showed up at the home. Now, when the 4 police officers arrived at the home, they actually prior knew Mr. Trevor Case. They knew his history potentially of mental health issues, and they were investigating the home. They looked through some windows, saw nobody inside, but one of the officers noticed an empty holster and a notepad. Now, here's where things unraveled and created this case. The police did not immediately go into the house. Instead, they stood outside the home for over 40 minutes. Some of the officers openly stated that they did not think Trevor was going to do anything wrong, that they didn't think anything would happen. But after 40 minutes, they discovered that the front door was completely unlocked, and then they decided to go in without a warrant. Now, as the officers searched the upstairs bedroom, a closet curtain suddenly jerked open, and one of the officers claimed that he saw a black object. He panicked and then opened fire, shooting Trevor Case in the arm, and then it passed through into his stomach. Now, afterwards, after he was detained, they searched the room and they found, I believe, a weapon in a laundry basket that was kind of nearby in the room. Now, there was an underlying conviction that attached to this case, but in response to his indictment, Trevor Case actually fought back, demanding that this warrantless evidence, that the firearm that was obtained, that needed to be suppressed because there was a violation of his Fourth Amendment rights, that the police officers entered his home without a warrant. This case eventually made its way all the way to the Montana Supreme Court, who ultimately rejected his arguments in a 4-3 split decision. Now, after the Montana Supreme Court issued that 4-3 split decision, Trevor Case took this challenge all the way to the United States Supreme Court. Now, when this challenge reached the Supreme Court, it triggered a massive institutional clash. Mr. Case argued that the Fourth Amendment requires strict probable cause before police can execute an emergency aid entry into the home, and he pointed out that the Supreme Court already struck down some broad community caretaking excuses in landmark Supreme Court cases like Coniglia versus Strong. But here is the wild part with this case. Both the state of Montana and also the Trump administration stepped into this fight actively arguing for a much lower standard of review. In fact, the Trump administration explicitly asked the Supreme Court to approve a sliding scale of reasonable suspicion to give police officers broad leeway to bypass warrants in these types of emergency situations. Now, when the final ruling actually dropped, it was a total 9-0 shutout. The Supreme Court completely rejected the Trump administration in Montana's actual push for that loose reasonable suspicion framework, calling it way too weak to protect the home. But the justices also completely rejected Mr. Case's arguments, ruling that probable cause is strictly tied to criminal investigations and does not apply to these type of life-saving interventions. Instead, the Supreme Court reaffirmed the court's prior standard in the case Brigham City versus Stewart, which states that police do not need a warrant or probable cause if they have an objectively reasonable basis to believe an occupant is seriously injured or facing imminent harm. Applying that standard to these exact facts, the Supreme Court ruled that because the officers heard a report that a weapon may have been involved, they saw an empty holster and got no response from anyone within the home, and they believed that maybe someone was going to harm themselves or potentially even them. They had an objectively reasonable basis to think that the homeowner might have actually harmed himself, and so they had to go in to protect him. The Supreme Court emphasized that the Fourth Amendment does not require police to stand by and do nothing when a human life is at risk. The Supreme Court stated in the opinion that we repeat today what we have held before. An officer may enter a home without a warrant if he has an objectively reasonable basis to believe that an occupant is seriously injured or imminently threatened with such injury. They found that the officer's entry in this case satisfied that test. So accordingly, they said that we affirm the judgment of the Montana Supreme Court. So in essence, the Supreme Court upheld the ultimate conclusion of the Montana Supreme Court, but rejected the actual analysis that they used to reach that conclusion. They found that the reasonable suspicion analysis was way too loose, and instead the Supreme Court applied the objectively reasonable test. They also rejected Mr. Case's position that probable cause should be the actual test. The Supreme Court found that that test is way too strong and would prevent police from performing these necessary life-saving duties. So the Supreme Court technically upheld the final judgment against Mr. Case, but they completely threw out and rejected the legal analysis that the Montana Supreme Court used to get there. They also stopped lower courts from expanding on a loose, watered-down caretaker standard. They officially actually also solidified a nationwide rule, which is if law enforcement can point to a credible report involving an objectively reasonable belief, they have the ultimate federally approved workaround to bypass your front door without a warrant and potentially confiscate property under the guise of an emergency. So that is the hidden reality behind the 9-0 unanimous ruling that was issued by the Supreme Court in the challenge Case versus Montana. The loose standards were rejected, but the new framework leaves a massive, unprecedented battlefield on your actual doorstep, and this is something that you should be aware of. There is no doubt going forward that there will be fallout where there's going to be other cases that are citing to this type of exception and this type of rule and the objectively reasonable belief standard that law enforcement need to go in for an emergency. And so this is something that is probably going to play out over the years where we see this pop up more. And as this develops more, as we get more cases involving this type of standard, I will let you guys know. But if you like this type of content and you want to make sure that you get it going forward, make sure you like, comment, subscribe, and turn on all notifications to make sure you never miss these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.